Hello friends, let me talk something about section 17 of Copyright Act, which plays very important role as far as the shoot of the infringement of the copyright is concerned. Because whenever the suit of the copyright infringement is filed before concerned honorable district court, then the question or the defense is that particular plaintiff is not the owner or author of that work in dispute. However, in that case, along with the factual aspect, this section plays very important role to consider or adjudicate whether the particular plaintiff is owner or not. As far as section 17 is concerned, there are two terms. One is expressed, one is implied. The expressed term is contract of service and implied term is contract for service. Now, what is the contract of service? Contract of service means during the employment of any employer, if an employee has prepared some work meaning thereby some artistic work, some literary work or dramatic work under the employment of that particular of that particular employer, then in that case that employer is the first owner of that copyright work. However, there is little difference in contract for service. Contract for service means any work which has been prepared or has been ready, not under the employment, but by availing the service of third person, then that third person is the author or the first owner of that particular copyright work. So it is called contract for service. The work which is prepared under the employment, unless there is an agreement, specific agreement, then the employer is the author, is the first owner of that particular work. The work which is not prepared under any employment, but it is prepared by third person by giving some remuneration, by giving some payment, then under that case that third person is the author and owner of that particular artistic work or literary work or dramatic work, whatsoever may be. So this is the basic difference between contract for service and contract of service. For example, if a book is prepared and is being published by some publication house, that publication house is the first owner ? Or the author is the first owner. This is unless there is specific agreement between publication house or the owner of the publication house and the author of that particular literary work. If that literary work is prepared under the employment, meaning if that author is under the employment of that publication house, then the publication house or the publisher is the first owner of that copyright work. I hope it is clear. Now, the same example. If that literary work is prepared by author but not under the employment of any publisher, then in that case that publisher has availed the service of author by giving remuneration or payment. Under such circumstances, that particular author is the first owner of the copyright. I hope it is, but obviously it is clear difference between contract for service, contract of service. And in section 17A of the Copyright Act 1957, the last two lines plays very important role. last two lines that begins with, but in all other respect, the author shall be the first owner of the copyright in the work. But in all other respect, meaning thereby, whenever any service is availed by any author, availed from any author or from any person, then that person or that author is the first owner of that particular copyright work. Rest of them, the employer is the owner of the first owner of the copyright work as per section 17A. So today I have said this about only section 17A, because section 17A plays very vital role in adjudicating the suit related to infringement of the copyright. Friends, if you like this video, please share it, please subscribe it and enjoy this. Thank you very much.